next we're very lucky to have attorney Don Freedman, who's going to talk to about the issues of guardianship and able. Does everybody have the handouts that are at the front desk? Yeah. Don, thank you.
Thank you. Hello, everybody. Guardianship is really about decision making, about the ability to make decisions. Guardianship is a protection that the law builds in to deal with people who are 18 or older and who have serious problems being able to make decisions. 18 is, for most purposes, sort of just an arbitrary age. You turn 18 and you have a party, right? There's nothing. Your body's the same, your head's the same, your education's the same, everything's the same, but the law says that something's very, very different when you turn 18. Before you're 18, it's your parents who have the legal authority, legal power to make a lot of decisions for you about schooling, about work, about where you live, about who you're with. That way.
Just if you want them to see.
Oh, okay. So that's when you're a kid, that's the story. When you're 15, 16, maybe 14, 15, 16, as a practical matter, as a parent, your legal authority doesn't mean very much. You know, how persuasive you are with your kids really becomes the factor in how well they do and how well they make decisions. But at 18, it really changes legally. At 18, the individual is able to make decisions on his own. Now, we spend a lot of time in the educational system helping people develop skills relating to making decisions about their lives. And that kind of training, that kind of focus is very, very important, particularly in the special needs context, where people may be more dependent on others, may be more apt to just rely on the advice of others. If they're relying on advice of people that we want them to trust, like you, or good people, then that's great. And that kind of compliance with good influence is a nice thing. If the compliance is with bad influences, people can't really evaluate it themselves, or they can't figure out what the impact of these decisions are on themselves, then it really becomes a problem. For most people, the law just lets things stand as they are. People grow to be adults, they make good decisions, they make bad decisions, they live with the bad decisions, they benefit from the good decisions. Hopefully they learn from the decisions and they go on. But the law doesn't step in and say you can't decide that. You can control your behavior, but it won't control where you live or where you work. There's no mechanism for doing that, gratefully. But at some level, with people who have less of an ability to make decisions, to sort of see ahead down the road, to understand what the consequences might be of their decisions. Not because of lack of experience, but because to recall what they've done in the past and will apply experiences that they've had in the past to their current situation. This is particularly an issue around medical treatment. What the law says is that for a doctor to provide a medical service to somebody, let's say as an adult, the doctor has to have the consent of the patient. The doctor can't just act, can't do the surgery or provide a medication without permission of the individual involved. For most of us, we kind of take that for granted. We know that, well, we understand some of what the doctor is saying and some we don't, but we can sort of have some sense of the risks involved, and we go ahead and make a decision about it. We do that based on things that we've learned and also just our native ability to evaluate options that are presented to us. We base it on our experience with similar situations in the past that we can remember. Things that went badly or didn't go well, and then we make a decision. But with people who have a reduced ability to manage that, cognitively, emotionally, people who might be overwhelmed emotionally by the thought of a decision, people who don't understand that they have a right to make a decision, or they don't know what a decision is. They're just sort of compliant. They just do what they're told. It's not that they're really weighing alternatives. They're just going with what is in front of them. We really end up with a problem.
So do we go to court and?
Not yet. First, I'm going to talk about ways to avoid court, because you don't want to go to court. You don't want to go to court.
Avoid the law.
No, like, do you go to like probate court and something?
Yeah, you can. But that's sort of the last resort. I wanted to start with the things that you really need to think about doing first for many reasons. One of them is the legal one. The law says that before you go to court, you have to show that there's no less restrictive alternative available. That language gets used in special ed, it gets used everywhere, it gets also in legal circles. You'll see it in some of the material at the back of the handout that's really copied from the probate court materials. They say that if we've got a problem with somebody being unable to make decisions, we have to try to address that in a way that is the least much a limitation on his rights and abilities and work as an adult. We have to identify the problem area and try to figure out the smallest way possible to deal with it. Now, so the law talks a lot about alternatives to guardianship, things that you can try before you go to court. And these are the things that really are, there's a good deal of discussion about this in the paper. I'll mention a few of the things. But they really start with training and education. And this really has to be a role in the schools. When you look at your transition plans in the context of your special ed, your IEP reviews and so forth, really from age 14, this whole issue of competency, decision-making, potential need for guardianship in the future is there. It's part of what the law requires to be examined, and the law requires that schools focus on this. If there are deficiencies in ability to make decisions, just like in reading, part of the education of a person as an adult is to make decisions. It's every bit as important as reading. So it should be part of the educational program itself. It should be part of the counseling activities in all of the areas where special needs students are involved. These can be social or church-related or anywhere where there's involvement. The idea is that people can be given options. They can be given choices. Small choices, they can help with the small choices. Learning to big choices. Sort of talking through decisions. You need to make a decision. What should you think about? Well, I should think about things that might have happened to me in the past. I should think about how this is going to help me now. I should think about what are the downsides for it. Is this going to hurt? What about the future? If it's going to hurt now, is it going to be important for me to be able to do this in the future? We really need to, decision making, we do it kind of automatically, but it involves serious decisions or review of all of those things. We really need to look at it that way. So counseling is involved as well. Now, there are many ways that there are even some legal approaches as alternatives to guardianship.
Like what?
Well, one is called a very simple legal instrument called a durable power of attorney. This is a sort of a permission slip. It's something that we can all have as part of our planning, our legal planning. What it says is that I am giving permission to somebody to help me in the following areas. To act as my representative in dealing with Social Security, or with the Boston Public Schools, or with the Department of Developmental Services.
Yeah, but what if he can't, like, my son, he can write, but like hand over hand.
Well, writing, the issue of writing is completely separate. The question about capacity is really capacity to sign a durable power of attorney involves a couple of things. One is that the person has to have the ability to understand his relationship with the people around him. Does he know the people he trusts? Does he know the people he knows? Does he know, can he separate them from the people he doesn't know and the people he shouldn't trust? Does he know you? Can he have the mental ability to have a kind of a relationship with somebody of trust and confidence? Some people don't have that ability. Their cognitive function, their emotional level is just at a level where they really can't recognize separations from themselves and other people. They can't distinguish between family and friends and strangers. But it's not a very high level of capacity that you need to be able to distinguish your parents and your siblings from strangers. So that's one piece of it. Another is that the power of attorney really involves the idea of giving somebody else permission to help you, to act on your behalf. That's all. You're naming a representative. And you have to have the capacity to understand what's involved in that. You know, that you're giving somebody else permission to act on your behalf in areas that you've spelled out in this thing. It takes a certain level of capacity to be able to do that. Most people do have that level of capacity, some don't. So that's one of the alternatives. And that what that can do is it gives you, the parent, permission to talk to these agencies on behalf of your child, so that you can, there's less of a risk that they're going to get, you know, sort of faked permission from the child, you know, directly, or they'll talk the child into something that the child really shouldn't be involved in. It gives you permission to act on his behalf and speak on his behalf. The healthcare proxy is another one of these alternatives. This is another, it's a document, it's a piece of paper. You can get them all over the place. You can get them on the web. Healthcare proxy is the same idea. What it says is that if I sign this, and if I can't make a decision about some medical thing that's supposed to happen to me, that I'm identifying somebody else who has the authority to make it for me. I'm saying that my mother or my father has my permission to talk to the doctor, go over the informed consent forms, and decide whether I should have surgery or chemotherapy or whatever the decision is in front of me. Now, healthcare proxy also can't be signed by anybody. First, you have to be 18. You have to be an adult. Secondly, you have to have the ability to understand what's involved with it. And it's similar to with the power of attorney. One thing is that you have to understand the relationships that you have with the people who would be appropriate to consider for this. You don't choose strangers to help make serious medical decisions for you. And if you can sort of, you don't necessarily have to choose a parent, it could be a sibling, it could be a friend. But the idea is that you have the ability to sort of weigh whether this is really an appropriate person to serve in this role. You may make a bad decision about it. We all make bad decisions. But the issue is whether we have the ability to make the decision, or do we really lack those skills in our minds and our brains to be able to do that. So that's another one. There are other things too that you can do with bank accounts. You can set up bank accounts that could require 2 signatures so that a person can't withdraw all the money himself. You can sort of structure help set up the person's, if he has some income and resources, you can set things up so that he has access to some but not others. So that you want him to have some access to things you only learn by having some risks, and you're going to make bad decisions, you learn with that. You just don't want to make bad decisions with something that's really important. So you sort of separate things out. If people have close relations with family or friends, or if they're in a group arrangement or in school, then it's more likely that they're going to have people available to help them make decisions. And those people are less at risk of a need for guardianship. So those are all kind of alternatives to guardianship, things to think about pursuing before you go that route. Well, actually, even a couple more. One is that there's a form in your school packet with the Boston Public Schools that once you are well, actually 16, because you don't have to be in school anymore, but at 18 you have the ability to make a decision about how, if at all, you want your parents to be involved in the review and decision-making about your IEP.
Yeah, I understand. I see what you're saying, but it's like, what if like I said, what if the child can't, like, he can talk, but not to put, he can tell me what's going on.
Well, I want to address your child specifically, because I think that's maybe a good case. But what I'm talking about here, sort of, if you look at the broad brush, something like, 15 or 16% of school-age kids are categorized as in need of special education or in some kind of special ed programs.
What society calls that?
That's a lot. Well, I didn't say abnormal. But that's that group. That's the special needs. That's the Boston SpedPac group. Some kind of percentage like that. Now, that's a huge number of kids. All those kids turn 18. Nobody's thinking that all of those kids need guardianship. The vast number, I think, would fall into this category that with education and counseling and some alternatives and some help, they have the ability to make decisions about their lives in a decent enough way. We get to the point though of, we look at, but you gotta look at everybody individually, and you're gonna look at somebody and conclude reasonably that they just don't have that ability to make a decision. They can't, these little ways of tweaking things and providing support. One is called supportive decision-making. There are all these approaches that are used to help people who have some lessened ability, but still some ability to be able to function. And most people with special ed needs are going to be in that category. But we are going to reach some who are not capable. We just can't, they can't make or communicate decisions. It's really the twofold thing. Not being able to make a decision means that if a doctor is talking with them about something simple or complex, they're just going to have no ability to understand the risks involved or what the medical treatment is or what the alternatives are. And we just feel that it would be just really a charade to sort of, even though the person might be nodding his head, we know he doesn't get it. And it's not fair to him, or it's not safe for him to put him in a situation where he can be exposed to that, to just saying yes to everything because he's trying to be nice and compliant. So at some point we need to think about guardianship, and guardianship is where the court really begins to get involved. Guardianship involves an individual, usually the parents, filing paperwork with the court, asking the court to review the situation and appoint typically the parent, but it could be somebody else, as the guardian of the individual. Now, it's a difficult process. It's a cumbersome process. The Department of Developmental Services, for one agency, has in the past been pretty good at helping people out, who, because of the expense involved, they'll do it themselves, but they're much less able to do that now with the regional office attorneys, much less than they were. So it's really a problem for people. There may be some help through the courts, some legal aid capacity for doing this, but it's very limited. So if you are involved in that, though, what it involves is getting the clinical team report assembled. The report is a little different. They're still using some old labels. They use mental retardation as one of the labels, not intellectual disabilities, but the law still calls it mental retardation. Other categories don't fit cleanly anywhere. Autism is one. Mental illness sort of fits in. But the idea is that there's something clinically going on that's making the person interfering with his ability to do the things that he needs to do to evaluate options and make decisions.
Say it's like some person goes, if you go to court, how long does this process take?
Well, depends on if it's an emergency situation, then it can happen very quickly. If it's not, it's going to take some months. Some of you can start before 18. But let me say one thing about the guardianship, and that's that the court is very open to the idea of limited guardianship. And this actually can go through much more easily. In a limited guardianship, dealing with a person who has just specific areas of where everybody's really concerned. By and large, the person gets by through the day and through the week. They'd be working, going to school okay. But there's some specific areas, and the most common one is medical decision making. I mean, it's for all of us. Who but another neurology specialist can really evaluate what a neurologist tells you, for options. So we're all in that boat. People with less developed capacities are going to be in a much worse shape for that, even in relatively minor things. So one form of guardianship that does tend to go through quite quickly is that if they're asking just for a limited guardianship, limited to medical decision making. So that, I think that's also the area where people are most at risk, and I think that's something that the court's really very comfortable with. So I think that's kind of what I want to say. Some cases or people or some descriptions of, yeah.
Once you have, if you decide to go to the guardianship, can you go back to that people?
Yes. No, it's not a one-shot deal. You can go back to have it adjusted up or down, either way, or have it eliminated altogether. You know, it's funny that I've had many people come to the office and they weren't aware of the fact that something had changed at 18. You know, they were a child who grew up in the house, special needs, past 18, past 18 without any particular notice. They might be now 35, and they hear me or somebody say, "Look, once they're over 18, you as a parent don't have any authority anymore. They're legally on their own." And I'll get this horrified look. Oh my God! I got to run out and get a guardianship. And I'll ask them, wait. So it's been, what was my example, 37. So it's a lot of years, 19 years. So the person has been without a guardian for 19 years. And you did not have legal authority to make decisions. Let's think about what happened or didn't happen as a result of that. You know, was he forced into some medical procedure that you wouldn't have wanted him to have? Was he denied a medical procedure that you wanted him to get? You know, if he got in some trouble with buying something he should have, were you able to get him out of it? Somebody, were things worked out informally to deal with these issues? Do people by and large listen to you as a parent because you have authority as a parent? Sort of appear to have authority as a parent. You know, but sort of people, if you're dealing with a system that you know, if you're dealing with a medical group, they know you, you know, whether there's a technical need for guardianship may not come up at all. So, yes. Yeah.
What's the difference between guardianship and the dual power of attorney?
Good, great. Good. Question is about the difference between guardianship and a durable power of attorney. Guardianship is court. You know, only a court can order the guardianship. Power of attorney is just private. It's between you and the individual involved. So it's a huge difference. It's not quite as powerful, on the other hand. You know, the person who signs a power of attorney can take it back. Whereas the court, the individual doesn't have any control over it. Only the judge can change it. But for most purposes, you know, we just find that it's sufficient. You know, in fact, if you have a power of attorney and a healthcare proxy, it's unlikely that the court would even give you guardianship. They would say that you've got stuff in place that should handle most things. Come back if there's a problem. So I really think that you know, pursuing that avenue of thinking about a power of attorney and a healthcare proxy for an individual with special needs who has a basic understanding to be able to understand those things, I think is really the way to go for really almost everybody. Unless, you know, if the person just can't sign that, can't understand that. Signing, I'm not sure, script, print, sign, you know, a person could be blind and not be able to sign the paper, but, you know, if the person has the ability to tell you to sign for him, that's enough. We're really not talking about physical capabilities, but mental ones. Yes?
So there are parents here who are on the brink of having students who are 18. Well, what could they do now in order to figure that out?
Well, I think right now, I think before 18 is a good time to think of it. SpedPac is evaluating this issue, presumably. I mean, it's part of the transition planning. And sort of their ideas about whether the person has the ability to understand a healthcare proxy or durable power, I think is a way to start. They should be talking to their physician or social worker or counselor or somebody about this. Yes?
My daughter's going through it now. She's 18, and so with the school, you know, we first went to a doctor and she filled out paperwork, and then the school psychologist filled out paperwork, and then they also brought someone else, I think another clinician, to do the paperwork, and so now it's up to me to go to court. And I think the Brook Courthouse on Tuesdays has free services for
Oh, good.
guardianship.
Okay, great.
On Tuesdays, you can get that information, the Brook Courthouse.
It's the family probate court downtown.
It's in downtown.
The Boston.
We can
It's
get
the
that
probate court in
information,
Boston.
put it up on the website.
That's great.
And then I can report back, actually, on how it went for me, because we haven't gone to court yet, but we're heading, I have all the paperwork done.
What time is this?
I'm in Dorchester, so I would go to the Brook Courthouse in Boston.
Yeah,
What time is it?
10, like 10 a.m. to 12
Oh,
p.m.
Date.
It's on the third floor outside of the register.
yeah, and we'll get that information, we'll put it on the website.
Yeah, right. So this is, you know, it's sort of, things can go either way at age 18. I mean, I've people that I'm working with where we talking with the doctor, talking with the same people, we decided that, well, you know, maybe we don't need guardianship. Maybe she has enough ability to go this other route. Let's try it first. You know, it has the, if the person, it can have some advantages for the person, you know, because she's still being treated as an adult.
So once the paperwork is done, how long does that process take?
Well, it's extremely, the power of attorney paperwork?
No, the guardianship.
Guardianship paperwork, well, that's extremely variable.
It took months for me to get all the paperwork.
Just to get the paperwork collected, right, and then it'll
Yeah.
take months to
And
get it
so now I
through
have
the
to go
court.
to court, so I'm not sure how long that will take, but once I have it done, I would be happy to talk in front of the group to let them know how it was.
That would be
going
very interesting.
From A to Z, and how the whole process went, and
Yeah.
you know.
Yeah, we have it's a new guardianship law, it's part of the problem. It's just a few years old, so it's really pretty experimental
What law is
still. We
that?
keep making changes. Guardianship law,
Yeah.
it's new, I mean, it's new, we just, you know, it's maybe 3 years now. And it's brand new, the procedures are different, people have the right to have counsel appointed for them. All the reports and forms are all different, and the courts are not uniform in how they're approaching it. So, but this is the point, it can be evaluated either within the school context or within a clinical context. If you're a children's hospital and a part of a clinical group there, they have a guardianship, they have an ability to evaluate guardianships there.
Oh, I have a psychiatrist who prescribes the medicine.
Don't make me,
They probably.
So I have a question.
Yes,
So say a parent dies, you have guardianship, now the child's still alive,
right.
what happens?
Yeah, the question is if the parent dies or just loses the ability to be the guardian, then you do have to go back to court to get somebody else appointed. It's not a matter of completely starting over again, but you do need a substitution. We often look, if it's possible, we look for co-guardians. Sometimes the co-guardian may be a parent and a sibling. You know, I think that's a great combination. Deals with this issue if the parent dies. It also means that the child has the chance to develop a relationship with a sibling while the parent is still alive to sort of handle the whole thing. But then the child under guardianship is seeing the sibling in this other role. Agencies see the sibling in this other role. It's not somebody new coming on the scene. So I think that's a good way to deal with that issue in advance of need, if possible, if the family resources are there. Yes, ma'am.
I'm hearing a lot of different things in the future around this needs, but, just the question is that some kids have a physical disability, some have a mental disability. What if we have a child that can function, but he has a learning disability?
All right, well, the issue is kind of the way the learning disability affects his ability to make decisions. For some kids, it makes them lousy readers or lousy in math. And that has nothing to do with guardianship. You don't have to be able to read or write or be good at it to make decisions. But some kids are going to have a problem where they really have trouble understanding what they see, remembering what they see, remembering what's said to them. Those relate much more to this ability to make decisions. So it could be, sort of moderate levels of concern, but very different.
And also you want to look at whether or not, you know your child best, but you also want to look at sort of what their cognitive testing has been across the years. And, guardianship is one of those things that you don't want your child to be taken advantage of. You want to make sure that they're not making financial decisions or medical decisions that they shouldn't be making because you know that they don't have the skills to make prudent and, basically appropriate and thoughtful decisions. That's when you want to look at it. But so my daughter's significantly disabled, where she's so cognitively impacted that I could never do a power of attorney for her because she doesn't know what a power of attorney is or what delegation of authority would mean. So it wouldn't be worth the paper that it was written on if someone were to challenge it. And I don't know if anyone would ever challenge it because I'm her parent,
Well, no, you really don't want to do that.
Right.
Because
You don't want to do it
gives you a
because
false
it's not
sense
going
of
to,
security.
exactly.
It's not going to work.
So guardianship is, people that are cognitively impaired, and it's going to impact the decision-making process. But even, there's different levels of cognitive impairment, you know? Like, it's not just at the MR age, it's sort of what are the impacts of the disability on the child? And that's why Dawn's giving you like the different types of guardianship, because it's not one or nothing. There's different types, and you look at what's the type of guardianship that I need for my child to make sure that his or her rights are protected and that no third party takes advantage of it. Because you don't want to be in the ER when your child's 18 years or older and they tell you you can't make a decision for your child and you can't do anything about it.
Great points. Cognitive is a key, but not the only key. And another is emotional. You know, people can be so afraid, so anxious that they can't make good decisions about medical care.
Yeah, mental health issues.
They'll deny,
Yeah.
you know, services. They'll refuse services when it plainly is in their best interest to go through with them. So it's a variety of things. It's not the physical. You know, you can accommodate the physical, you can accommodate vision, you can accommodate hearing, and in all these systems, there really are this idea of accommodating, of finding ways to get the person involved as much as possible in decisions is a real key. And agencies have a responsibility for doing that. Vision would be a problem if you can't get in the front door to get to the doctor to sign the consent form.
Yeah, and just to make it more understandable in terms of like a parent, right? So if you have a child with a severe cognitive impairment, that's probably someone you need to look at having guardianship for. You have a child that has bipolar disorder or a mental health impact that affects their judgment at any given time. That's probably something you want to look at guardianship for. Children on the autism spectrum, it's really going to depend, because that varies greatly. You know, some children on the autism spectrum are brilliant, you know, but they don't have any social or emotional skills, so then you might have to look at some areas of guardianship. Other kids on the autism spectrum are severely mentally retarded. We all understand what that means. So their kids you do want to look at guardianship for. It all depends what your child's disability is and how that disability impacts their decision making and their ability to communicate decisions. And I'm not saying just in terms of you know, verbal output versus using a machine or writing it down. It's understanding what they're taking in, and then they can communicate back something that's responsive to what they're being told. So it all really does vary. So as parents, we all have to look at what is my child's disability, or what's the impact on my child as a result of that disability. It's not just the name of the disability, it's how it impacts your child.
Right. It's not the name. It's not what I was going to say. It's not the label. You know, it's the what's underlying the label. It could be very different labels, but it goes to this question. Yes, ma'am.
Testing, I know a lot of when you're testing new drugs, transitioning, and the nose, like, they're only good for like 6 months or whatever. I'm worried about like support. If she's 17, you want to schedule it like 17 and a half. I don't want to schedule it too early. I don't want to schedule it too late because, you know, Mass Health will only pay for one within a certain amount of time. So I'm trying to figure out how long that paperwork is good legally so that I can schedule the test and the paperwork will be good by the time the paperwork is expire.
It depends. I mean, it depends on a couple of things. If it's a developmental, like a mental retardation situation, then generally that's good for 6 months. If it's more of a mental illness situation, then it's good for a month. You really have to wait. You can file before 18, but this is something you really need to plan. You know, if there's an ability to get some advice at the courthouse, then this is exactly the question you should ask. My daughter's going to need this. When should I file? When should I get the reports? These are questions we go back to the clerks about, because they're the ones who are going to decide the things eventually.
Do you have a business card?
I'm here for education, that's all.
So can I ask a question?
Sure.
Social Security, are they gonna require, if my child's on Social Security?
This is a good question that to do with Social Security. This is a good alternative to guardianship thing. If the only income the person has coming in is from SSI or Social Security Disability or child's benefits, then Social Security has its own kind of guardianship tool to use to protect that money. Someone can be appointed as a representative payee, rep payee, and then the checks come to that individual for deposit and use for the. They don't belong to that individual, but that person becomes the manager of that money. Let me just finish the thought. So that's a good, just like, it's a good way of, you know, and I have many clients who, that's the financial problem that they've got, is what's gonna happen with those benefits. And the Rep 8 way is a good way to handle that.
What are child benefits?
Child's benefits are if they, you know, it's survivor's benefits. If a parent has died and they're minor children, not yet through high school, that's child's benefits. Child's benefits can continue after age 18 or after high school if the child is disabled and the parent is retired or disabled or deceased.
Oh, well, I'm retired. Well, I'm not working, I'm in school.
Yeah, but you're not a child.
Yeah, but it's like my son's like 16. So like,
If someone is, as an adult, has a work record with Social Security and is eligible for Social Security disability benefits, then that person's child under age 18, or 19 is high school, has to do with high school graduation. You know, it's usually 18, can be 19 if they haven't graduated high school, can be eligible for child benefits. Parent, if there's a disabled father and a mother providing care for a minor, the mother may be eligible for mother's benefits.
Okay.
There's a lot.
It's like, there was something that was, it was a workshop I went to. It's called like a foster, like, when they beyond, if there's special needs, like when they're beyond 18, it's like a foster grandparent, foster parent program.
I don't know. I don't know about that one. Any other, got one word on ABLE, I know it was on the thing as something I was going to talk about. It's really a different topic. This is ABLE, A-B-L-E. It's a new federal law, not implemented yet, so it's just something to put a spotlight on. It's a new federal law that's going to allow families and individuals to hold money, let it accumulate without having to pay taxes on the interest, so that it can be used for the disabled individual in future years. It's going to be a way of saving money, even though different from the SSI asset limit, sort of separate from that, and also separate from taxes. We haven't seen the regulations have been issued, hasn't been implemented. Massachusetts is going to have its own version for Massachusetts state taxes, so just stay tuned to that. It's going to be useful. It's going to be a useful, I think, piece for people to even to save small amounts of money for the future for special needs situations. I think we're.
Go ahead, ma'am.
Oh, sorry. Sure.
At 16, like daughter's IEP meeting, I want to start getting the 688 referral started now. Would you say that's a good idea to get it started earlier?
Yep. 688 is sort of it was the state law that sort of set up this whole program of transition planning in schools, part of 766. It was just the statute.
How old is your daughter?
She's 16.
Yeah.
I don't think they'll do it that early. It's too early. They,
No, it's not on the regulations.
well, no, on the transition services, no, but she's saying
They
for
won't
the
actually
688
start it, but they
referral.
will start getting
Oh,
the
referral
process.
to the-
If you
to
push
an
hard enough,
agency?
they
Yeah.
will start getting it, because I have
Yeah.
BPS helping me, and they will start. You do
Yeah,
have to do a little pushing.
Yeah. All right. Now this is a good point.
Okay.
Actually, there's a little piece in the.
I don't want to be.
Because I've seen
One of-
agencies say no, not yet, so
Well,
that's good to
yeah,
know.
but even if it's not technically time, there's actually a piece in that, one of the articles I have on some transition years talks about this guardianship, but also talks about that. One of the transitions has to do with transitions to adult services. And I think it's never too early to start that. What you want is at the time that they make the decision, you want them to know your daughter, to know the family, to know the situation, you want to be involved with them. There's a much greater chance of locking in at the right time. But sort of build those, go to those meetings, that's critical. Know your area office. Ask them for respite help, ask them for anything they can give you to sort of get you on their radar.
Very good.
Okay?
Thank you, Don.
Thank you, Don.
Thank you.
Hello, everybody. My name is John Santamano, the Vice Chair of Boston SpedPac. Thanks for coming tonight. I just want to let you know that we're recording this, so if you missed anything and want to go back and watch it, you can. And then all the documents that are here tonight and additional ones are already on the website. And there's a page under the library called Accessing Services Post BPS or After BPS. So they're already up on the website and they're live. The only problem right now is that they're PDFs, so they're not translatable, but we'll work on that too as we get going forward. So, next is Carolyn.